Hello and welcome to the Minimum Competence episode for Friday, June 6th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have the SEC lawsuit dismissal, OpenAI's appeal in the New York Times case, and Trump's push to defund legal aid for millions of low-income Americans. Let's remember, all around us we see a world of paradox, deep, ironic, and intractable. A world in which the hungry nations export food, the richest nations slip into demoralizing economic recessions, the strongest nations go to war against the smallest and weakest and are unable to win. A world in which the revolutions against tyrannical systems themselves become tyrannies. And read today's legal news. On this day in legal history, June 6, 1934, the United States Securities and Exchange Commission, or SEC, was established as part of the sweeping reforms of the New Deal. The SEC was created by the Securities Exchange Act of 1934 in response to the stock market crash of 1929 and the ensuing Great Depression, which exposed widespread fraud, manipulation, and lack of oversight in the financial markets. Its primary mission was and remains to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. President Franklin D. Roosevelt appointed Joseph P. Kennedy, a former stockbroker and businessman, as the SEC's first chairman. The choice was controversial. Kennedy had profited handsomely from some of the same speculative practices the SEC was meant to prevent, but Roosevelt believed that Kennedy's insider knowledge would make him an effective regulator. The SEC was empowered to regulate the securities industry, enforce federal securities laws, and oversee the nation's stock and options exchanges. Among its early duties were requiring public companies to file detailed financial disclosures, registering securities before public offering, and monitor insider trading. The Commission also played a key role in restoring investor confidence in U.S. capital markets during a time of deep financial mistrust. Over time, the SEC expanded its reach, responding to new financial products, trading technologies, and crises. From investigating corporate accounting scandals like Enron and WorldCom to managing the regulatory fallout of the 2008 financial crisis, the SEC has remained a pivotal force in shaping American financial law. It continues to evolve, now addressing issues such as crypto asset regulation, ESG disclosures, and algorithmic trading. Speaking of that selfsame SEC, U.S. District Judge Reggie Walton dismissed a lawsuit challenging the SEC 2020 rule changes that made it more difficult for shareholders to submit proposals at corporate annual meetings. The rules, enacted late in President Trump's term, raised the ownership thresholds and lengthened holding periods required to file shareholder proposals. They also introduced stricter resubmission requirements for proposals previously rejected by shareholders. The plaintiffs, including the Interfaith Center on Corporate Responsibility, As You Sow, and shareholder advocate James McRitchie, argued the changes disproportionately harmed proposals on environmental, social, and governance issues and reduced long-term shareholder value. They claimed the SEC failed to assess the benefits of such proposals before implementing the rules. Judge Walton rejected these claims, ruling that the SEC adequately justified the changes under its mandate to promote efficiency, competition, and capital formation. The SEC, which had defended the rules during both the Trump and Biden administrations, argued that the reforms ensured shareholder proposals had broader relevance and potential for meaningful corporate action. The 2020 vote on the rule changes split along party lines, with Republican commissioners in support. While the SEC declined to comment on the ruling, the plaintiffs expressed disappointment and affirmed their commitment to corporate engagement on environmental and social issues. OpenAI filed an appeal challenging a court order that requires it to indefinitely preserve ChatGPT output data in an ongoing copyright lawsuit brought by the New York Times. OpenAI argues the order conflicts with its user privacy commitments and sets a troubling precedent. The preservation directive was issued last month after the Times requested that all relevant log data be maintained and segregated. OpenAI CEO Sam Altman publicly criticized the order on social media, affirming the company's stance against actions it sees as compromising user privacy. The appeal, filed on June 3rd, asks U.S. District Judge Sidney Stein to vacate the preservation requirement. The lawsuit, filed in 2023, accuses OpenAI and Microsoft of using millions of Times articles without permission to train ChatGPT. In April, Judge Stein ruled that the Times had plausibly alleged that OpenAI and Microsoft may have encouraged users to reproduce copyrighted content. The ruling rejected parts of a motion to dismiss the case and allowed several of the Times claims to move forward, citing multiple examples of ChatGPT generating material closely resembling Times articles. President Trump's 2026 budget proposal includes a plan to eliminate the Legal Services Corporation, or LSC, an independent agency that funds civil legal aid for low-income Americans. The proposal seeks $21 million for an orderly closeout of the organization, which had requested $2.1 billion to meet growing demand. The LSC supports 130 nonprofit legal aid programs that assist with issues such as evictions, disaster recovery, and access to public benefits. Critics warn that the move would devastate legal aid access for millions, particularly in rural areas and the South. In Louisiana, for example, there is just one legal aid lawyer for every 11,250 eligible residents. Legal aid leaders say they are already turning away half of those seeking help due to budget constraints, and the proposed funding cut would further limit their reach. Organizations like Southeast Louisiana Legal Services and Legal Aid of North Carolina would lose 40 to 50% of their funding, jeopardizing services for communities still recovering from recent hurricanes. Legal Services New York City, the largest legal aid provider in the country, has implemented a hiring freeze in anticipation of these possible cuts. The proposal revives a long-standing conservative goal. Past Republican efforts to dismantle the LSC date back to the Reagan era, and Trump made a similar attempt in 2018. The Heritage Foundation has accused the LSC of supporting controversial causes, but legal aid advocates argue the organization is vital to community stability and fairness in the justice system. And in a piece I wrote for Forbes last week, I discussed how the IRS has quietly released with no fanfare the underlying code base for its direct file program on GitHub, marking a rare moment of transparency in government software. At the center of this release is something called the Fact Graph, a logic engine that models tax rules as interrelated facts rather than a linear checklist. Built using XML and Scala, the Fact Graph interprets ambiguous tax data, identifies contradictions or omissions, and suggests paths forward, all in a transparent and declarative format. What sets this apart is that, unlike proprietary tax software, direct files logic isn't hidden. It's open, reviewable, and potentially improvable by anyone. This move not only demystifies some of the inner workings of tax enforcement, but also sets a precedent. If algorithms are mediating our legal obligations, we should be able to see and understand the rules they follow. The release is particularly striking in an era of eroding public trust in institutions and increasing reliance on automated decision-making. While direct file itself remains limited in scope and its future is uncertain, the open sourcing of its logic engine may have laid the groundwork for broader change. Other agencies, from state tax departments to those experimenting with AI-driven policy enforcement, could adopt similar transparency, allowing the public to engage with and even help refine the systems that govern them. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Robert Schumann and comes courtesy of Christopher Zbinden. This week's closing theme is Robert Schumann's Toccata in C major, Opus 7, a dazzling showcase of Romantic-era pianism and one of the most technically demanding works in the standard repertoire. Composed in 1830 and revised in 1833, the piece earned a reputation early on as a pianist's Everest. Franz Liszt himself dubbed it the hardest piece ever written. Clocking in at just over 5 minutes when played at tempo, it's a relentless whirlwind of perpetual motion, requiring both physical stamina and interpretive precision. The toccata form, traditionally a virtuosic keyboard piece emphasizing dexterity, becomes in Schumann's hands something more cerebral. Beneath its bravura surface lies a structure built on two contrasting themes, developed with intricate counterpoint and rhythmic displacement. The left hand must execute rapid repeated notes and wide leaps with precision. Meanwhile, the right weaves through syncopated figures and chromatic runs, creating a dense musical texture. Schumann dedicated this piece to his friend Ludwig Schunke, who had recently died at the age of 23. That personal connection adds an emotional layer to a work that might otherwise be heard as pure technical spectacle. Unlike many showpieces of the era, Schumann's toccata isn't just difficulty for difficulty's sake, it's an expression of obsession, energy, and youthful ambition. For a composer better known for lyrical piano miniatures, the toccata is an early signal of the depth and range Schumann would explore in later works. As this week closes, it offers a fitting send-off, intricate, driven, and a little manic, in the best romantic sense of the word. Without further ado, Robert Schumann's Toccata in C major, Opus 7. Enjoy.